May I be pardoned? There are 3 criminal revisions against an order rejecting discharge in a vigilance case at Balangir. They were being listed before your lordship regularly. But since a few weeks, they have not been listed. And the trial judge there, my lords, is pestering. The next date is 6th. Before the 6th, any date. Before the 6th on any date.
No, tomorrow is a hearing day.
Yes, or Friday.
So, Friday, this tide of matters are coming. We'll see next week.
Monday.
Pardon me, my lord. JCRL 54/18. Accusing custody since 2015, my lord. Only for bail, my lord.
My lord, this is the criminal division of the year 2017. Challenges to the rejection of discharge application.
Please give it.
Conviction matter out of 10 years.
Lordship, filing an interim application on the ground of illness of his wife. The petitioner
Please give.
urgent necessary lordship surgery.
It will be listed.
My lord, the Lorraine Court below rejected the discharge petition, my lord. I have mentioned several times your lordship was not listed, my lord. The matter is posted on 10th, my lord, for framing of charge, my lord.
Give it.
I'll date may be fixed, my lord. Special act. Criminal of special act. My lord, I note 47, my lord. Brother of the appellant one has been expired, my lord. Kindly taken up.
That instruction you have taken, Mr. Das, his brother has expired in item number 47. He made a mention yesterday.
My lord.
That is how it has been listed. So whether that
Yes, yes.
it is correct?
Yes, ma'am.
All right, IA number 748 of 24. This is an application for interim bail. Bring out that 47. On the ground that the elder brother of the petitioner passed away on 27/3/2024, and in order to perform the obsequious ceremonies, the presence of the petitioner is very much necessary. Document relating to the death of the elder brother has been annexed to the interim application. Land Council for the state has obtained it in instruction.
Report on. Report.
IIC Aska Police Station, dated 2/4/2024, which indicates that the averments taken is correct. The written instruction is taken on record. Considering the submission, averments taken in the so-and-so written instruction obtained, I am inclined to release the petitioner on interim bail for a period of 2 weeks. Matter be listed in so-and-so. Will file the surrender certificate. Matter be uploaded immediately. Land trial court shall not insist for production of certified copy and will accept the bail bonds. So given an order taking that will produce the certified copy on or before 9th of April 2024. Yes.
Original certificate in the course of day.
Yes, it will be uploaded.
May I please, my lord?
Yeah.
My lord, one criminal appeal, my lord, IFA stay of conviction. It was directed to be listed in the week commencing
Give
from
it.
published.
Press matter relating to criminal revision. Press matter relating to criminal revision.
Yeah.
Pardon to mention. Well, criminal revision number 567 is a fresh. 567 of 2023. Lordship, it's a fresh matter.
Take your breath. Be relaxed. आराम से फोन सत्तर ओवर नहीं
Sir,
बसी जान और 2 minute पर कहिए. Yes, Mr. Panda, what is your matter?
I beg pardon. Tired of bail application lordships. Court की चलो diligent bail lordships.
Please give it.
This Friday may be taken up.
This is an appeal against an order of the OPID court.
Yes, where is Mr. Patra?
My lords, earlier The petitioner had filed criminal appeal 647 of 2020, which your lordship was pleased to allow by order dated 27/3/2020.
What is the number, earlier number?
647.
Okay.
That related, my lords, to a rejection order of the trial court for release of certain bank accounts, my lords. And your lordship was pleased to allow that by that order dated 27/3/2023. Now, when the petitioner went and furnished his compliance to your lordship's judgment, my lords, it was found that two of those accounts, they had been erroneously written. The numbers were erroneously described.
Two of the accounts means where?
My lords, two accounts, your lordship may look at.
Which you have mentioned in the...
Yes, I have mentioned in my petition, my lords.
No, annexure 1 of that CRLA number 647.
In CRLA, the present CRLA 23. Your lordship may look at annexure 1 of page. That will be page number 7, my lords, of this brief.
Page number 7, Mr. Panda.
That is a charge sheet.
Right.
And the order begins at page 9, my lords.
9.
Your lordship may look at the third paragraph after the word heard. Learned counsel for petitioner submits that the above mentioned two accounts of Jagannath Foods and Aquaculture Private Limited and Ajay Kumar Chaudhary in Axis Bank Satyanagar branch has been freezed by the IO in connection with EOW PSK 6 of 2020. Subsequently, pursuant to order dated 28/3/2023 of the Honorable High Court of Orissa passed in Criminal Appeal 647 of 2022, this court directed EOW Bhubaneswar to defreeze accounts as per list of account numbers submitted earlier by accused petitioner in their previous petition dated 4/5/2022. But account numbers mentioned in petition dated 4/5/2022 vide annexure 1 was wrongly typed as 9160006799034 and 91701005384542 instead of the account numbers 916020067990384 and 9170100538454474, and due to such typographical error, account number such and such and such and such of Jagannath Food and Aquaculture and Ajay Chaudhary in Axis Bank Satyanagar could not be defreezed in compliance with the order dated 28/3/2023 of the Honorable High Court passed in Criminal Appeal 647 of 2022. Now, this contention of mine was vehemently objected by the learned specialty. That is reflected in the next paragraph.
No, please read the submission which was made by this learned special public.
Yes, I am reading that.
Yes.
On the other hand, learned special PP for the state vehemently objected such submission of learned counsel for petition. Learned special PP for the state submits that account number 916020067990384 of Jagannath Foods and Aquaculture Private Limited in Axis Bank Satyanagar has not been freezed by the IO in connection with the case, and as regards account number 91700100538454474 of Ajay Chaudhary, petitioner in their previous petition by annexure 1 has not mentioned about the said bank accounts, and against the impugned order of this court arising out of the previous petition dated 4/5/2022, petitioner has also not prayed before the Honorable Court to defreeze account number 9170070010053845474 of Ajay Chaudhary in Axis Bank, Satyanagar, Bhubaneswar.
Okay, then what is the operative part of the order?
Yes, operative part, your lordship may see. the last paragraph of page 10.
Yes.
On perusal of the case record, it is found that account number 91602 0067990384 of Jagannath Food and Aquaculture in Axis Bank Satyanagar and account number 917-010-0538454474 of Ajay Chaudhary in Axis Bank Satyanagar do not find place as per the list furnished in the petition under Annexure 1. They were incorrect numbers were given, Millers. I agree, those numbers are not there in my petition. And in respect of the above two bank accounts, there is no specific direction in the orders of the Honorable High Court of Orissa to make the bank account defreezed. In view of the assigned reasons, this court is of the considered view not to issue any direction to the police of EOW Bhubaneswar to defreeze bank account number 91602006799038 of Jagannath.
Okay, so Mr. Panda, so whatever you have stated that it is a typographical error in your petition which was filed before the court. Now, but one contention that was raised by the learned
State
public
Council.
prosecutor
Yes.
that it has not been, one of such account was not been seized. Of course, he has not given any finding that this last number is 384.
Again.
So and so has not been freezed by the IO in connection with this case.
To that effect, my lords, the court has not given any finding.
No,
but
that's
that
all right.
account
But
is seized.
what is the correct state of affairs?
No, that account has been seized.
No, that he has to
Yes,
say.
that
Mr. Have you filed any reply to this?
No, today I am filing.
Today तांको कॉपी देलेनी आपण फाइनल डिस्पोजल ପାଇଁ ଅଛି कोन गोटे तांको से पढिबे नि 80 पढिबे कोन 8 पढिबे
ଗୋଟେ extra ପଡୁଛି।
कोन से अकाउंट विषय कोन लिखि जंदी आपण
Paragraph 4, my lords may see what we have written.
Yeah.
That on further verification, it is ascertained that both the above account numbers were wrongly mentioned, for which both the accounts could not be defreezed. It is further ascertained that the correct account numbers which were actually frozen are 9170-100-5384-5474 stands in the name of Ajay Chaudhary, and 91602-0067990384 stands in the name of Jagannath Foods and Aquaculture Private Limited. But no written intimation regarding freezing of account of Jagannath Foods and Aquaculture was given by the bank, and freezing of the above two accounts are no more required in the case. This is their stand.
Oh, if it is no more required, so release it.
Exactly.
Take down the learning Mr. Pandal and counsel for the এটা পুনি সেকেন্ডটা পুনি কোন
আজ্ঞା
সেকেন্ডটা কোন উইথ जो আসছি
সেটা হচ্ছে প্রিভিয়াস যে ক্রিমিনাল অ্যাপিলটা 647
CRL number 23 of 2024. This appeal has been filed under Section 13 of the Orissa Protection of Interest of Depositors in Financial Establishment Act 2011, hereafter OPID Act, challenging the order dated 19/8/2023 passed by the Lenin designated court OPID Act Cuttack in city case number 5 of 2020, which arises out of EOWPS case number 6 of 2020 in rejecting the petition
at Annexure 2
filed by the appellant Messrs. Keshari Estate Private Limited.
The petition is at page
to direct defreeze the accounts number so and so, এই লেখা হয়েছে third, fourth paragraph of so and so, है পুরাটা সেটা লিখে দেবেন, है which has been preached by the IO in connection with so and so, which corresponds to so and so. It appears that earlier the petitioner approached this court, appellant approached this court in CRLA number 647 of 2022, challenging the order dated 12/7/2022 passed by the presiding officer, designated court of PIDR, Cuttack, wherein the prayer made by the appellant to defreeze the bank accounts maintained in different banks has been rejected. This court by order dated 28/3/2023 passed the following order. Quote the operative part of the considering the submission to last version. The petition was filed before the OPID court on the ground that in Annexure 1 of the petition dated 4/5/2022, the account numbers have been wrongly typed as so and so instead of so and so. So like I say, Mojire due to contention. And due to such typographical error, account number so and so could not be defreezed. In spite of the order dated 28/3/2023 of this court passed in CRL number 647 of 2022. The learned court, after considering the contention raised by the learned counsel for the appellant, so also the learned counsel for the learned special public prosecutor, rejected the petition on the ground for the on perusal of the case record 2 up to stands rejected version. The learned counsel for the state has produced the written instruction wherein in paragraph number 4 it is mentioned as follows for this paragraph. In view of the written instruction filed, I am of the view that since in Annexure 1 the account numbers have been wrongly typed, the
Your Lordship may say, since in the Annexure 1 to the petition dated 4/5/2022.
Annexure 1 to the petition dated 4/5/2022, wrongly typed. The account number so and so shall be read as account number so and so, and the account number so and so shall be read as so and so. With the this application is disposed of. Yes.
Urgent copy.
লেখা হিসেবে মজুরি তো তার ঠিক। Yes, madam.
Lordship, on criminal revision number 567 of 2023, Your Lordship, it's a fresh matter and has been filed against the order of Special Judge Vigilance Cuttack in rejecting the petition under section 239 of CRPC.
Okay.
Lordship, this matter is very urgent as Your Lordship, 12th April re
Give your memo. Give your yes.
Obliged.
Item 2.
Yes, appeal.
The conviction is 20 years.
It's a conviction matter.
Juvenile has been convicted for 20 years.
Okay, hard admit call for the trial court report. Yes, next.
Because of the fact that AB is there, 376 AB.
So have you filed any application for bail?
No.
Before not filed.
It's appeal. I have to file. That's why notice. Then good.
Just a minute. So far as this
439 is concerned, notice is not.
that requires only right of the so-and-so in connection with the bail application.
Yes,
It's not for other things. So since you have not filed the bail application, the moment you will file the bail application, notice will be issued. At this stage, where is the, if suppose you will not file the interim application,
Then
and
noted off.
so is necessary to give an opportunity to
In such a case also, it's only prescribed to 439.
right
Because 439 says I will not file an application on 439 here. Even if I file the appeal bail, my lord, 389.
No, you have filed an appeal challenging the order of conviction.
My lord.
I've admitted it. Now, whether the informant is required to be heard in the appeal, if it is heard on merits after 10 years, let us say, because the only provision it deals with that at the stage of consideration of the bail application.
Bail take note of the 439 only.
Right. So,
And I will not file an
like in
application
the SC/ST matter,
My lord.
in all matters, the informant has a right to be heard.
Hard, my lord.
But so far as if the only offense is 376 AB, then only it is stated that only at the bail stage that opportunity is to be given, not that
Bail means of 439.
right. No, 439 how kimba taku
389
upon jetale 389. But it cannot, since you have not filed that
Yes,
application, the question doesn't arise now. Okay.
All right.
Next.
May any date be fixed?
Are you file you can once you file the interim application,
No, so
what
far,
do you want now?
So far admission, because
I have already admitted call for the trial court record. If you have not filed any interim application for bail or stay realization of fine, then why it will be listed? It will come in due course, right? Yes.
May I please?
Item 3.
Yes, Mr. Mishra.
The appellant is convicted under 13(1)(d), read with 32 and section 7 of the PC Act, and sentenced to undergo RI for 4 years and to pay fine rupees 2,000. The appellant was all along on bail, and here I will say that, my lord, the order of conviction is out and out perverse.
Yeah, Mr. Das.
Yes, my lord, I have received the copy. I will file my appearance by the end of May 2024.
Admit call for the trial court report. He was on bail allowed, stay realization of file, urgent certified copy, free copy of the order be handed over to Mr. Das. Name shall be reflected, and you will file the appearance memo. Yes, Mr.
Urgent to certify to me.
By the end of May, my lord.
Okay.
Oblige.
Item 4.
May proceed. The appellant, running page 33. The appellant has been convicted under section 304B and 498A. The maximum sentence is 7 years. Lordship may see the flag C. Your Lordship granted bail to the mother-in-law, and the LCR is available there in the.
LCR
is available in the flag C, my lord. Kind of glance.
No, LCR has already been called for in another.
In CRLA number.
Let it be placed for hard admit call for the trial court record. Stop. It is stated by Mr. Dwivedi that since the co-accused persons, namely Kama Barik, has preferred CRLA number 1356 of 2023, challenging the self-impugned judgment and order of conviction, and the trial court record has been called for. The registry may verify the availability of the so and so, and if it is available, the interim application for bail and stay realization of fine shall be placed for consideration for order, sir. Yes.
Date may be fixed.
It will come when we commencing from 15th April.
Yes, I am supplying the copies of the deposition.
Deposition copy supplied to the Land Council for this. Yes.
Item 5.
What is this defect number 9 as for SR not removed? Legible copy of so and so. Okay. What is the CRLA for? Mr.
Bail.
Bail. So, SC/ST matter. Notice sufficient. When? Just a minute. इसके Can I pass over? Yes, of course. Next.
Item 6.
Kindly have a pass over, Your Lordship, on behalf of Mr. S. Paul.
No, case diary whether it is available.
Item 6, my lord.
Yeah.
My lord.
Item 8.
This appeal is in nature of bail application under the SC Act. Last occasion, I had submitted my deposition of 6 witnesses. In the meantime, 3 more witnesses have been examined. I got today. Man, can take now day after tomorrow, madam.
Huh?
Can take now day after tomorrow. Today I got
You
madam
have filed 6.
6. In the meantime, 3 more examined. Today I got. I will supply today, my lord. Can take now day after tomorrow.
Supply to the State Council
madam,
and to the
today.
informant also.
Yes, madam.
My lord, posted to 5th for evidence, my lord. 5 4 की पुणे again posting evidence.
No, whether the any other material witness is left out or not,
my
that
lord,
is
my
to
lord.
be seen.
Out of
Eyewitness have already been examined, madam.
my lord, some vital
So go
witnesses
through
are
the
there.
3 statements which he was giving. If you, after going through the same, if you say that some more material witnesses have been left out, we may wait till the examination. But if
You also may fix it on the 10th, madam. 5th
Right.
is there. Madam, 10th.
Lieutenant Counsel for the appellant submits that he has supplied deposition copies of 6 witnesses to the Lieutenant Counsel for the state, so also to the Lieutenant Counsel for the informant, and filed the same for the court. But since 3 more witnesses have been examined in the meantime, we will supply the same during course of the day to the Lieutenant Counsel for both the parties, Lieutenant Counsel for the state and Lieutenant Counsel for the informant, and file also for the court. The Lieutenant Counsel for the informant submitted that in the trial court, the date is fixed to 5th of April 2024 for examination of some more witnesses. In view of such submission, put of this matter in the week commencing from 15th April 2024, if any further witnesses are examined on the date fixed, the Lieutenant Counsel for the appellant shall obtain the certified copy of the deposition of those witnesses also and supply the same to the parties and file the same for the court. Yes, next.
Item 9.
May I please, Your Worship?
The number for the informant not filed. Okay, you have received the case diary, Mr.
No.
Huh?
No. I'll have a glance on the page 21, rejection order matter.
21. Accused so-and-so produced, he, okay, offences on he released on interim bail on dated as per the direction of the court and subsequently did not appear in the court in obedience to the order so interim bail. Though the case was of the year, but till that charge has not been framed. Released on bail, there is so-and-so. So it's a offense under section 307.
Yes, sir. I have annexed the injury report at running base 24. Simple injury. One inside cotton and simple in nature on the left elbow. Running base 24.
Acha. Sorry. The injured is
Sukhchan Hyal.
Or the Lieutenant Counsel for the petitioner, appellant Lieutenant Counsel for the state. In spite of service of notice on the informant, none appears. No, none appears for the informant. Considering the submission made by the Lieutenant Counsel for the appellant that the appellant is in judicial custody since
17/1/2024.
17/1/2024. And charge sheet submitted?
Yes, sir. Charge sheet
And
submitted
charge
on
sheet has-
25/3/2021.
Charge sheet has already been submitted under section
Under section 294,
Yes.
324,
307, 506 of IPC, read with section 31R, 31S, 32VA, 31V of SC and ST PO Act.
Hello. And after going through the injury report of the injured, Sukhchan
HIAL,
HIAL, hello, which shows that he has sustained one injury on the left elbow, which has been opined to be simple in nature. And after hearing the learned counsel for the state, I am inclined to release the petitioner appellant on bail allowed.
Obliged, Lord.
Item 10.
10 will pass over on behalf of Mr. Bell.
CD available? Hello. Here, my lord, answer antecedent ଅଛି 307 case. He has not filed the comprehensive affidavit. He has already filed. He has not given a copy to you. No, madam. So why have you not given the copy of the comprehensive affidavit which you have filed? Hand over a copy. Will take up this matter next week. Learned counsel for the state submitted that there are 5 criminal antecedents against the appellant. The learned counsel for the appellant has filed the comprehensive affidavit relating to the status of those cases. However, a copy of the same has not been served on the learned counsel for the state who has received the case diary. Put up this matter in the week commencing from 8th of April 2024. Copy of the comprehensive affidavit be served on the learned counsel for the state by tomorrow. Hello? Okay.
Item 11.
Item 11, my lord, there are 2 appeals arising out of the same affair. First time it has come, notice me, my lord, under 3 SC Act.
All right, extra copy to be served. Notice to be issued. CD, CA, confirmation letter. Put up this matter on such and such. Yes, next.
Item 12.
May I please? All
Yes.
queries has been granted bail. I'll turn to page 22.
Fresh matter.
Fresh matter.
Fresh matter notice you
Notice of the present petitioners are my lord ST person. The both the appellants, my lord, they belongs to ST community, my lord. So no necessity, notice is required, and in the charge sheet also, they have been deleted with this SC/ST Act.
Where is the charge sheet?
Well, that aspect has also been dealt in the bail order. The lower court has also told that in page 11.
Learned counsel for the assurance submitted that the accused persons are SC/ST by caste. Most of the
I have given the copy, madam.
no, that was your contention.
No, my lord, this is the copy of the charge sheet. The appellant number 2.
No, this will not do. You have to file an entire copy of the charge sheet. This is not receiving like extra copy to be served, notice to be issued, CD, CA, and compliance report to be obtained.
And another appeal is also pending before the court, my lord. Criminal appeal number 9 of 2024.
See that if the case diary is available, Mr. Dar.
9 of 2024. CRLA 9 of 2024.
Mr. Chand, Land Council submits that connected appeal for application for bail, connected appeal for bail is subjudiced in respect of the co-accused, which is numbered as CRLA 9 of 2024. Place this matter along with so and so.
May paper next week.
That keep fix up it.
March date
date fix up
9.
So
petition number 2. One is a NALCO employee.
15/4/2024 for them. Yeah. Copy टे दे दियो भाई.
May पे 8 में नाल्को employed.
Next item.
Item 13.
Connected number टा लिख लेता.
Press matter criminal decision, your lordship. A notice is to be issued to the information.
Here, my lord, I have filed application only for modification of the condition number 4. Modification of condition number 4.
Just a minute.
It's for order dated 16/2/2022.
16/2.
Well, that is BLAPL number 6494/2021 while granting bail.
Bail was granted in BLAPL number
6494/2021. And while granting bail by order dated 16/2/2022,
Yes,
the Supreme Court has imposed certain condition, including condition number 4. That is, the prisoner shall not leave the state of Odisha without prior permission of the court.
without prior permission of the court concerned.
My lord. I have approached the concerned court, my lord, on 2 occasions, although it was allowed. But my lord, all procedural aspects have been taken care of, and which has constrained me not to materialize my work in time. So instead of that, may I pray, my lord, kind enough, with the permission of the IO, that will meet the purpose. Wherever I will go.
कोर्ट केबे परमिशन मना करछेंती की
मना के कर
मना करना तो असुविधा
मना करछने माने that after months to that was allowed, and in the meantime about 3 years is going to be passed. Instead of
I have filed my affidavit.
And they have filed
affidavit.
Counter affidavit. Madam, see, page 5 is relevant.
Affidavit by the investigating officer.
Yes,
I
It was filed on 22nd March 2024.
Fine.
They could miss any. They have taken the ground.
ये number को please come to the eye. तादेर affidavit file है जी कुछ और चीज़
1600/2024 IA number
1600 of 2023 has come for appropriate orders. State Council says that an affidavit has been filed by the investigating officer. Whether it is available on record? Huh?
I have received the copy. They have given the copy to me.
Copy not solved. अच्छा केबे फाइल करेगी सेटा
एटा बते दै छथि
23/3
हां
23/3 से आसीनी पळे आसु काली पॉड न आसु लेखन the land and council for the state submits that an affidavit has been filed by the investigating officer.
Yes.
In view of the order dated 6/3/2024, and copy of the same has already been served on the land and council for the petitioner. Put up this matter on 5th of April 2024 with the affidavit of the investigating officer. Yes.
Item 15.
15, my lord. Prisoner petition has come, my lord. Flag D.
Flag D.
D, my lord.
Flag D.
D for Delhi.
They don't flag D. Okay. He mentions that I want to engage Mr. Devasi Sahu. That's
Again,
you are filing the Vinama?
already filed.
Already filed.
Yes.
Okay, that's all. So, what do you want now?
Proceed, take up.
Okay. Have you received? It's a bail application.
Yes, yes, he is
You
supplied.
have
the
received the case
Yes,
letter. All right. Move the application. Just a minute. 15. BLAPL number 12732 2022. Manu MANU Duria. Is it the first bail application or earlier rejected?
The first bail application. In respect of co-accused persons, he filed me law.
ନାଇଁ ମୁଁ ଆପଣଙ୍କ କଥା କହୁଛି ଆପଣ କୋଆକ୍ୟୁଜ କଣ ଆପଣ ଆଗରୁ ଆସିଥିଲେ କି
ନା ନା BLAPL ଫାଇଲ କରିନି
BLAPL
439 first application.
Okay, so what is the date of custody?
12/7/22 milo. Taken on remand.
So what are the offenses under
Of
which
offense milo 20B2C and 2529 of the NDPS Act.
20B2C, 25 and 29?
Aye.
You were apprehended at the spot?
No, nothing was seized and nobody has apprehended at the spot, and the persons who have been named in the affair, they have been granted bail.
No, what was found from your possession?
Nothing was found. Lord, what happened, my lord? The police officials have got information that the petitioner, along with others, my lord, they are trying to transport contraband articles through 2 vehicles, my lord. And after getting such information, my lord, the police officials have searched and intercepted 2 vehicles. At the time of interception, the 2 vehicles, persons who were sitting in the 2 vehicles, they have fled away from the spot. And where the petitioner along with others, that is the prosecution story, my lord. And nothing was seized from the possession of the present petitioner.
But your name finds place in the affair?
In the affair. Petitioner along with others' name have also
How they came to know? If everybody fled away,
they suspected that these persons, yes, these persons were present at the spot.
Okay, this, let us say, this occurrence took place on 9/3 and you were arrested after 4 months.
Yes, no. 12/7/22.
Acha, 2 years, 4 months.
Again.
Okay. So what about any other material and what about the criminal antecedent?
Criminal antecedent that has been reflected in the last occasion, that is chronology.
You
report.
filed?
Yes, that is there, Milo. It flag C, Milo, that comprehensive affidavit.
You have got 13 cases?
Yeah. Again. In all cases, my lord, and apart from 13 cases, my lord, 2 cases that is belong to NDPS Act.
So why you will be granted bail?
In both the cases, in all cases, he has been granted bail. And in another case, my lord, that nothing was seized from his possession, he has been granted bail in another case. That is, my lord, BLAPL.
While he was on bail, he has committed this offense.
No. That is BLAPL 4365 of 23. In another case, he has been granted bail.
No, what the Learned Counsel for the state submits,
yes,
that if you are misutilizing your liberty and one after another case is right from, as it appears, 2013 onwards.
Again.
There are cases against you.
Again.
And you are going on bail, committing one offense, again taken, again released on bail. So even though in this case there is no such direct evidence, but there are also 2 NDPS Act cases against.
Yes, exactly, my lord. In other case, my lord, in another case, NDPS offense under section 20B2C, in that case also he has been taken on remand, my lord. for which, my lord, your lordship has granted bail.
Apart from that, one is 302.
In all the cases, my lord, he has been granted bail.
For some time, let the charge be framed. Charge frame learning.
That I will take instruction.
Put up this matter in the week commencing from 6th of May 2024. Learned counsel for the petitioner shall obtain whether charge has been framed or not. Yes, next.
My lord.
May plus.
Item number 16, it's not your case.
Is my lord. Lordship, in this matter, I am through virtual mode.
Yeah.
My lord, on the last date of hearing, the matter was fixed for the surety document verification. Lordship, it is the same case in which one co-accused has been released on bail yesterday by my lord only in the BL appeal number 12444. The fact of the case are that he is in jail from the 7th March 21, and out of 15 witnesses, six has been.
No, it's all right, but what about the
surety verification?
Okay, yesterday one co-accused was granted.
One co-accused, yes, Lordship, and the bail number is 12444. It was
Dr. Kaliro.
item number.
What is the appeal number, Mr. Manohar?
Lordship, it was 12444/23. 37 number item.
But 37 kouchandi. Same bail order passed. The date of arrest is same.
Yes, Lordship. Yes, Lordship. Same FIR, same date of arrest, same custody.
All right, allowed.
I'm obliged, Lordship. I'm obliged. Deeply obliged, Lordship.
Yes, next.
Item 17.
He was granted bail for 3 months, not order. Yes.
Sir, may I please, Your Lordship? Sir, I filed an interim application on the last one, Lordship, called for the instruction, Your Lordship.
You have filed an interim application.
Yes, Your Lordship.
On the ground of ailment of the mother.
Yes, Your
of the petitioner. Yes.
Let it come next week, my lord.
You have received the copy of the interim application.
Yes.
And also sought for instruction.
Yes, my lord.
All right. Learned counsel for the IN number 1649 of 23. This is an application for interim bail on the ground of ailment of the mother of the petitioner. Learned counsel for the state submitted that the matter may be taken up next week as instruction sought for has not been received. Put up this matter in the week commencing from 8th April 2024.
Item 18.
Yes, Mr. Panda.
Your Lordship had called for a status report. I believe that has come. And your Lordship had also asked me to furnish details of the sureties to the State Council.
Outsider?
That was done. Yes. Resident of Chhattisgarh. And I am in custody since 11/3/2018.
4 witnesses have been examined. And what is the total number of witnesses as per charge sheet?
14 minutes.
14. What is your custody date you said?
I am in custody since 11/3/2018.
Never been released on interim?
No.
The Learned Counsel for the petition, Learned Counsel for the state. Mr. Panda, Learned Counsel for the petitioner submit that the petitioner was taken into judicial custody on 11/3/2018. And in the trial court, out of 14 charge sheet witnesses, only 4 witnesses have been examined so far. And in view of the delayed disposal of the trial, the bail application of the petitioner may be favorably considered. Land Counsel for the state has produced written instruction received from IIC Sonpur Police Station dated 26/3/2024, which indicates that the Aadhaar card and ROR of 2 local sureties, namely Chaitanya Deep and Ganga Kumbha, are verified, and it was found is genuine, and the sureties are ready and willing to take the petitioner on bail. Considering the submission made by the Land Counsel for the respective parties, the period of detention of the petitioner in judicial custody, the slow progress of the trial, and keeping in view the residual down in the case of Muhammad Muslim so and so, I'm inclined to release the petitioner on bail allowed.
Arjun.
Item 19.
Yes, Mr. Roy.
My lord, I may be permitted. Your lordship. My lord, your lordship, may kindly have a glance at the last order. The only evidence against me is my own confessional statements made to the police.
Last order is 14/3/24.
Indeed, your lordship.
No, State Council on that day furnished a list of 5 material witnesses. The names have been given, and there was a direction to the IIC Barcode Police Station to appear before the trial court, receive summons, and ensure the attendance of those 5 witnesses. And then you were asked that if the witnesses are examined, you are to produce the certified copy of the deposition. So what happened after that?
My lord,
Have you? How many witnesses have been
my
examined?
lord, one has been examined and not any. No, this is one. Only one has been examined, and none of the ones that your lordship has reflected in the order. Neither my witness, to whom I state to be the material witness, nor the state council's witness list. Only one was examined on that.
The order
Again, but they have not been produced.
No, produce it's all right, but he furnished a list on that day.
Again, the state council.
So, now why only one witness was produced and you did not produce the rest 4?
My lord, that one also was not named in this order.
Okay, so
all 5.
That means none of the 5 have been examined.
No, man.
So what is your instruction, Mr.
No instruction received, but the letter was sent on 16/3/24. 16/3.
No,
and that date was fixed to 18 million.
Okay. No, it's all right. He could have at least said that, sir, we could not comply that order. Have you talked with him? Whether...
No.
So if you have got the order on 14th or 15th, when you sent it?
Received order on 18 million.
All right. So let him appear and or let you obtain instruction why, whether due to this time constraint he could not comply that order, and what is the next date?
My lord, 11th of April.
Then you can produce him on 11th. 11th April is it is holiday. Are you sure that it is on 11th? कौन पे छुट्टी अछि कि 11 तारिख दिन?
रामनवमी.
रामनवमी ताले छुट्टी थिबो, तळकोट छुट्टी थिबो.
नहीं तो ईद छुट्टी नहीं.
ना ईद अछि. ताले तळकोट छुट्टी नथिबो. अच्छा. So why don't you ask him to appear just now so that everything can be ascertained?
I will take instruction.
All right.
He will produce.
Okay. The London Council for the petitioner submitted that in spite of the order dated 14/3/2024, none of the 5 witnesses mentioned in the said order were produced before the Lennon trial court by the inspector in charge, Barcode Police Station, for recording their evidence. Land counsel for the petitioner submitted that the date is now fixed to 11th of April 2024. Land counsel for the state submits that the IIC of Barcode Police Station shall appear before the Lennon trial court, that is Additional Session Judge Deoghad, in ST case number 17-04 of 2020 during course of this week, and receive summons in respect of 5 witnesses, namely Khushbu alias Komal Agrawala, Kamal Agrawal, Purnachandra Sahu, Niranjan Das, Chandu Dhivar, and Subhama Nag. Subarna, Subarna Nag, Subhamal Hiji, Subarna Nag, and ensure their attendance on the date fixed. Put up this matter in the week commencing from 22nd of April 2024. बाकी से जो last portion जा लिखा है order dated 14/3/2024 last operative part, if witnesses are examined, set up रखी देवे, है ना? Free copy of the order be handed over to the Land Council for the state. 22nd for 2024. Yes, next.
Gratefully, Lordship.
Item 20.
Item 20. May I please know? Actually, item 20. When I was filing for element of the petitioner's mother mailing.
That is IA number 124. Instruction has been sought for.
Yes, my lord.
And
Sought
what
for, but not received so far.
To get it will take
Yes,
it on
yes.
8th of April. IA number 1244 of 23. This is an application for interim bail on the ground of ailment of the mother of the petitioner. Land and Council for the state submitted that instruction has already been sought for on the interim application, and matter may be taken up next week. As prayed for, place this matter in the week commencing from 8th April 2020. Yes.
Okay.
Item 21.
In this case, my lord,
Yeah.
the connected file is posted to 8th week commencing 8th April, my lord.
Connected file माने कौन? कितना?
ଆଉ ଗୋଟେ accused lord se
Number टा कौन?
DLAPL number 11276
11
276 of
273
276
6 ना 3
70
76
अच्छा
26
आगे
11,276 ठीक तो of 2023
week commencing 8th
8th 8/4/2024. Yes, Mr. Naik, so it will come at all. Ms. Nandaland Council appearing for the petitioner submitted that the connected bail application, that is BLAPL number 11276 of 2023 is
26 my lord 276
11,276 तो of 2023 is posted to 8th of April 2024. Put up this matter along with so and so. है ना?
Item 22.
copy दिए है कि कौन?
Mr. Pujari, Anil Pai.
was present first hour, my lord.
You have received the case diary?
Yes, sir.
All right, pass over.
Item 23.
May it please, Your Lordship. Your Lordship, the deposition copies had been called for from the learned court below in item 23, Your Lordship.
You want adjournment?
No, Your Lordship.
Oh, I have called for.
Yes, Your Lordship. That is at flag B, Your Lordship.
And you have received the deposition
Yes,
copy?
Your Lordship.
You have also received.
Deposition copy.
So, as it appears, 5 witnesses have been examined.
Yes, Your Lordship. Your Lordship may look into the
Is it the first application or earlier
This
rejection?
is the second application, Your
So
Lordship.
which was the first one?
Your Lordship, first application was BL Appeal 4422 of 2022, Your Lordship.
So the huge amount has been received from different persons, and when you approached this court earlier, there was a direction that deposit a sum of rupees 15 lakhs
Yes, Your Lordship.
before the presiding officer designated court, and then you will go on deposit that amount. The amount is 5 crore 24 lakhs and all.
Yes, Your Lordship.
So
Your Lordship, I am only one of the formal directors of the company, Your Lordship. And the
it's an
audit-
economic offense unless
Yes, Your
the
Lordship.
amount is deposited, there is no.
Your Lordship, I agree to that, Your
And
Lordship.
5 crores is not a small amount. You have the number of depositors have been cheated and of their hard-earned money, and with false assurance this has been done. So
Your Lordship, that is why I want to take Your Lordships to the deposition of PW5, Your Lordship, who has specifically stated that this present petitioner has never even induced the depositors, Your Lordship.
no, most of the this type of cases are mostly proved through the documentary evidence.
Yes, Your Lordship. Even
So the how much amount they have deposited in the account, and what whether that amount is available or not, and then that would corroborate the prosecution case that this false assurance was given that this would be doubled or tripled within very short time, and accepted, but then the company was closed, and the innocent persons were cheated of their hard-earned money. That is how the amount is 5 crores and all. So these
Your
are all
Lordship,
cheat fund companies.
yes, Your Lordship, I agree to that, Your Lordship. My only contention is that keeping in mind that despite an order had been passed to deposit some money and I was not able to do so,
Yes,
Your
then
Lordship.
remain there.
Your Lordship,
Within the
at
4
this point of time, Your Lordship, I may be permitted to deposit some amount of money and the rest in installments, Your Lordship.
Yes, file an affidavit. How much you can? This is 5 crores, and you are in custody since when?
Your Lordship, I am in custody since 5/5/2022, Your Lordship.
So
And
what is the total number of witnesses?
Your Lordship, total number of witnesses were 27, Your Lordship, out of which 5 witnesses have been examined, Your Lordship. And out of them, Your Lordship may look into the deposition of PW5, Your Lordship.
No, I am not. It is a question of you have not completed even 2 years, and 5 crores is the allegation, and directing for expeditious trial.
Your Lordship, the bail application of the co-accused, we had been directed to submit an affidavit, Your Lordship, as to how much we can deposit.
If you want to file affidavit, file the affidavit. If you, that's how you'll make the deposit of that amount. This is matter is of 2023, and all right, I'm granting one opportunity file. The learned counsel for the petitioner seeks some time to file an affidavit. The Mr. Patra learned counsel submitted that the total amount collected from the depositors giving false assurance is 5 crore 24 lakhs, 36,700. When counsel for the petitioner seeks some time to file affidavit to how the petitioner will deposit the amount by way of installment in the court below.
Your Lordship, this bail application may be taken up with BLAPL 556 of 2020.
Of this matter with BLAPL number so and so. Get the number?
BLAPL number 556 of 2024.
Yes. Next.
Item 24.
Petition is in custody since 21 August 2020. 21/8/2020.
Have you received the case diary?
Yes, my lord.
Out of 15 charge-sheeted witnesses, the 3 witnesses have been examined. And
Status
PW
report has been called for.
Yes.
Where is that?
Status net. Status mobile.
Status report to 9.
9 and mobile.
Look on the learned counsel for the petitioner submitted that the petitioner is in judicial custody since Kebedo
21/8/2020.
21/8/2020, and he has instruction that out of
15 charge-sheeted
15 charge-sheeted witnesses, only
3 witnesses have been
3 witnesses have been examined.
And last witness examined on 22/4/2023.
And then PW 3 was examined on
22/4/2023.
Stop. Let a status report be called for from the Learned Trial Court, that is Second Additional Session Judge Bhubaneswar, in TR case number 328 of 2020. For such purpose, file be placed usual order for the matter be listed on 15th of April 2024.
Item 25.
Please, Your Lordship.
Yeah.
My lord, here in this case, the present petitioner being a lady inside custody since my lord 8/7/2016, my lord. For the offense,
The status report was called for. What
My lord.
happened?
last reference chapter
24 charge sheet witness to 17 witness ହେଇଛନ୍ତି. And the status report indicate that the case is delayed due to non-appearance of the informant, who was the sub-inspector of police Kantamal police station in 2017. And his present place of posting is not known to this office. After correspondence, it was known that he is posted at Bhadrak district, and accordingly, message was sent. Bailable warrant was issued against him, which was returned by so and so with endorsement. S.I. Dibyalochan is in sub-jail Bhanjnagar in connection with 302 case. Yes, Mr. Your informant was taken into custody in connection. Informant is a police officer. He was taken into custody in connection with a 302 case, and he was in Bhanjnagar jail. Subsequently, he has been released on bail, but thereafter he is not appearing before the trial court to give evidence, and non-bailable warrant of arrest has been issued against him. First bailable warrant, then non-bailable warrant. Now the case is getting delayed. This man is in custody since 2016.
oh ma'am, this is a lady.
What is the offense here?
My lord,
NDPS.
20B2C.
20.
One.
And you are a man from?
My lord, she is a woman. So,
You have never been released on interim bail.
my lord, twice on interim bail.
Hmm.
Once on 2177 of 2019 PLAPL for 2 months, and another one 9103 of 2019 for 3 months.
And you surrendered at right time.
My lord.
So what is that initial date when you were taken into custody?
My lord,
8/7.
8/7/2016.
And here is a case charge sheet submitted under section 20B2C. 20B2C. No other offense. Right. Yes, 20B2.
20B2C.
Are the learned counsel for the petitioner, learned counsel for the state. Learned counsel for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case on 8/7/2016, and he was granted interim bail twice. First time for 2 months and then for 3 months. And after availing the same, he surrendered at right time. Learned counsel further submits that in view of the slow progress of the trial, since the petitioner is a lady and as he has not flouted the terms and condition of the interim bail order, the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail, mainly on the ground that it is a case of seizure of commercial quantity of ganja, and that the petitioner has been charge sheeted under section 20B2C of the NDPS Act. As per the order dated 18/12/2023 passed by this court, the Learned Trial Court has submitted the status report, wherein it is mentioned that out of 24 charge sheet witnesses, 17 witnesses have been examined, and the trial is getting delayed for non-appearance of the informant, who was the sub-inspector of police at Kantamal police station in the year 2017. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody, the slow progress of the trial, the conduct of the petitioner in complying with the terms and condition of the interim bail orders, and keeping in view the ratio let down in the case of Muhammad Muslim, so on so. And no criminal antecedent. And that he is having no criminal antecedent. I am inclined to release the petitioner on bail allowed.
Oh, please. Oh, please.
Item 26.
Offense under section 450 and 376 6 POSCO Act. CORAM cell on
Dairy Achi?
Lord, in this matter, Lordship, in this matter, I'm through virtual mode. Lordship, on the last date of hearing, the matter was fixed for the surety document verification. The petitioner is in JC since 10th of Feb 22, and as per the last order passed by my lord on the 22nd of January, out of 16, only one witnesses has been examined. So Lordship had directed me to submit the
date when you are taken into custody.
Lordship 10th of Feb 2022. 10 फरवरी 2022.
10/2/2022. Okay.
Yes, Lordship.
What is
And out of 16, only one charge sheet witness has been examined yet, Lordship.
total number of charge sheet witnesses is 15.
16. 16. 1 6.
And one has been
Only one. Only one, Lordship.
verified genuine document of so and so, bail order so and so, and for taking found the documents are genuine and sections are genuine.
If your Lordship permits, I would like to apprise one more thing while discussing the last bail application in the month of July last year. Lordship has directed that the charge to be completed in the next 6 months. But till now, only one witness has been examined, Lordship. So the direction of this Honorable Court has not been followed.
Mr. Sam Manohar, Land Counsel, appearing for virtual mode, submitted that the petitioner was taken into judicial custody on 10/2/2022, and he has been charge sheeted under section 20B2C25 and 27 of the NDPS Act and section 25 of the Arms Act. When he approached this court for bail earlier in BLAPL number 5891 of 2022, as per order dated 3/7/2023, while rejecting the bail application, this court directed the Land and Trial Court to expedite the trial and to conclude the same within a period of 6 months from the date of framing of the charge, and the petitioner was given liberty to renew the prayer for bail if the trial is not concluded within the said period. Land Counsel for the petitioner submitted that out of 16 charge sheet witnesses, only one witness has been examined, and therefore the bail application of the petitioner may be favorably considered. As per the order of this court, the Land and Trial Court has submitted the status report, which is which also reveals status report date kar diyantu. That is 18/1/2024, which also reveals that only one witness has been examined. Land and Counsel for the state, however, opposed the prayer for bail mainly on the ground that it's a case of seizure of commercial quantity of ganja, and the petitioner is a man from Uttar Pradesh, Raebareli district in the state of Uttar Pradesh. The Land and Counsel for the petitioner supplied the names, address, and documents of two local sureties to the state for verification. And today the Land Counsel for the state has produced the written instruction received from IIC Chitrakonda police station in the district of Malkangiri that the genuineness of documents, that is Aadhaar card and ROR of the two local sureties, namely Paritos Ben and Hari Haldar, were verified, and it was found that the documents are genuine and the sureties are also genuine. What about the address verification?
My lord, so far as my instruction is concerned,
anything received? Because on the last date you said that you have already sought for instruction and you have not received. That was on 22/1/2024.
No, that not received.
All right. The learned counsel for the state submitted that even though instruction has already been sought for through the Superintendent of Police Malkangiri from Superintendent of Police Raebareli, Uttar Pradesh for address verification of the petitioner as given in the post title, but the instruction has not been received. Considering the submission made by the learned counsel for the respective parties, the period of detention of the petitioner in judicial custody since the order passed by this court on in BLAPL number 5891 of 2022 as per order dated 3/7/2023 has not been complied with, and keeping in view the slow progress of the trial as mentioned in the status report, I am inclined to release the and further taking into account the seizure of commercial quantity of ganja and bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention, I am inclined to release him on interim bail for a period of 3 months, subject to condition that the Paritos Bain and Hari Haldar shall be the two local sureties for the petitioner. While on interim bail, the petitioner shall appear before the learned trial court on each date when the case would be posted for trial and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail.
Lordship, I am deeply obliged.
Item number 28.
May I please? The co-accused.
This is a 302 matter, Your Lordship, and CD is available in PLAPL 12659 of 2023, and the matter is fixed to 5th April. I was checking from the
5th, acha.
Let it be tagged with
Mr. Tripathi, learned counsel for the state submitted that the connected matter, that is BLAPL number
12659 of 2023.
12659 of 2023 is fixed to 5th April 2024. And in that case record, the case diary is available. Put up this matter on 5th April 2024. Yes.
Okay.
Item number 29.
May I please? The offense is 302 of IPC. Out of 37 witness, 17 witness has been examined. Today I am filing the deposition copy of the 17 witness.
File for the court also. The learned counsel for the petitioner files the deposition copy of 17 witnesses.
Out of 37.
Examine in the trial court and give copies of the same to the learned counsel for the state, who seeks some time to go through the same.
CD से भी दरकार है। CD भी दरकार है।
CD नहीं की?
चार्जशीट दे दीजिए। चार्जशीट दे दीजिए क्या?
अच्छा, oh, it a fresh matter. All right. Learned counsel for the state also seeks some time to produce the case diary and obtain instruction about the criminal antecedent. Put up this matter, Louis commencing from 15th April 2024.
Item 30.
So if I may please your lordship, my lord, on behalf of Mr. Mohanty, my lord, may kindly have a glance at the last order, by virtue of which, my lord, the state council, learned state council was directed to obtain the CD, and if it was available in a connected bail application, moreover, the learned state council was directed to obtain instructions if during interim bail he has misutilized his
after that, he was granted bail for a period of 3 months, and after availing this return, submitted that bail application of one co-accused is sub judice Supplied the. Now you have received the case diary.
My lord, I have received the case diary. What has happened in this case, my lord? Another co-accused male matter was yesterday. It was before your lordship. That is BLAPL number.
Say 172.
CDA BLPL number 172 of 2023. In that case, your lordship is directed to examination of some eyewitnesses.
Kali order tai.
Kali thila se case ta. Se examination of eyewitnesses thila. That he only personal appearance pe achi Kali of the IAC.
Acha.
Se case.
You want the matter to be
today the IAC had come to me, my lord, in the morning, and he has stated that he has already served the summon to the witnesses, and the matter is fixed to 8/4/2024 before the court.
8/4.
Yes, let it come tomorrow, my lord.
Acha. Could have learned counsel for the state submit that the connected matter, that is BLAPL number 172 of 2023 is posted tomorrow. Tomorrow na day after tomorrow. Kali. Which number item
Lord, on the website it is showing us 5th of April is the next date.
Acha. Which is posted to 5th of April 2024. Put up this matter on 5th April along with कर दिया BLAPL number 172 of 2023 है ना.
My lord had also directed for instructions regarding if it had misutilized during the.
Say direction to nahi.
Nana direction.
This is already the direction to them. He stated that I have been released on interim bail and in BLAPL number so and so and for 3 months, and direction was issued that the state council to obtain instruction whether he has misutilized his liberty while on interim bail or not. That order was passed on.
I will get that matter.
All right, next.
I'm grateful, your lordship.
Item 31.
May I please your lordship, my lord? My lord, last time my lord was kind enough to direct the instruction. In the meantime, my lord, the petitioner is in custody and twice he has been granted bail by interim bail by your lordships. Out of 32 witnesses, only 7 witnesses have been examined.
No, last time when the matter was taken up on 23/20/24, you were not present.
Yes, I sorry, my lord, I beg your lordship's pardon.
So now it is coming for the second time. So you have received the case diary?
Yes, ma'am. Yes,
okay. So what is your submission?
My humble submission to lordship, my lord. Only 21 kg of mod only recovered from the gunny bag which was kept besides the petitioner. Petitioner along with another person. There are 2 accused persons.
No, now this is item 31. When you were taken into custody?
Yes, my lord.
22/11/2020.
22/11/2020. And offenses under which charge is submitted?
20B2C.
That is the only offense. Is it your first application or earlier you approached this court?
Well, I applied for 2 times. Your lordship has granted interim bail for 3 months.
Twice.
That is annexure 1 series I have given.
When you were granted interim bail for the last time?
Last time, my lord, 29/9/22, and I complied the direction by surrendering, my lord.
So now what is the stage?
Stage, my lord, only 7 witnesses have been
out of?
Lord,
what is the total number
out of 32? Out of 32 witnesses, only 7 witnesses.
So what is your instruction about the utilization this period, whether he has misutilized the liberty when he was granted interim bail twice?
I will take that instruction.
Take that instruction. Learned counsel for the petitioner submitted that after the petitioner was taken into judicial custody in connection with this case, since 22/11/2020, he was
2 times.
22/11/2020, he was granted interim bail twice. And after availing the same, he surrendered at right time and he has never misutilized the liberty. And he has received instruction that out of 32 charge sheet witnesses, 7 witnesses have been examined. Let a status report be called for from the Lennon trial court, and while submitting the status report, The Learned Trial Court shall specifically indicate as to whether the petitioner surrendered at right time after availing the interim bail period or not. The Learned Counsel for the state shall obtain instruction through the inspector in charge of Bhanjanagar police station as to whether during the period of interim bail the petitioner, there is any allegation against the petitioner to have misutilized his liberty. Court of this matter we commencing from 15th April 2024. Free copy of the order be handed over to the Learned Counsel for the state.
Obliged.
Item number 32.
May I please, my lord?
Yes, Mr. Panda.
20B2C of NDPS Act. Commercial quantity of ganja. The petitioner is in custody since 7/3/2020. Out of 22 charge sheet witnesses.
7/3/2020.
My lord. Out of 22 charge sheet witnesses, only 8 witnesses have been examined. I have annexed the deposition copies and
Charge sheet under section
20B2C of NDPS Act.
And you have received the case diary.
Fresh matter.
Oh, fresh.
My lord, once he has been granted bail, I have annexed the bail order. Page 9 for a interim.
ଗୋଟେ ଥର ଯାଇଛନ୍ତି କେତେ ମାସ ପାଇଁ
3 ମାସ ପାଇଁ ଯାଇଛି ଲୋକାଲ ମ୍ୟାନ।
ଆଚ୍ଛା ସେଇ ଟାଇପ ର ଅର୍ଡର ଟା କରିଦେବେ ଯେ 7/3/2020 ରୁ କଷ୍ଟଡି ହେଲା 7/3/20 ଚାର୍ଜସିଟ ହେଇଛି 20B2C ରେ 22ଟା ୱିଟନେସ ରୁ 8ଟା ହେଇଛନ୍ତି granted once interim bail for 3 months and surrender at right time ହେଲା ସେଇଟା ରିପୋର୍ଟ ଟା ମୋର सेम थे टाइप आउ ये मिसयूटिलाइज करछि ना सेम हां 3 months पे जाइतला 15/4 आसीबो यस
and I may pardon
15/4/2024 status report will come and we will obtain the instruction whether you have misutilized the liberty or not. That yes.
Item 33.
Yeah. Madam, I could not hear you properly. Yes.
On previous date, it was withdrawn.
It was withdrawn. Acha. In the BLAPL is disposed of. Acha, inadvertently typed. Acha. Instead of a will. Then order dated से मैं kindly correction तो. हाँ online. All right. In the order dated, registry has pointed out that in the order dated 21/3/2024, in the last line, instead of ABLAPL, it is inadvertently mentioned as BLAPL. The word BLAPL in the last line of the order dated 21/3/2024 shall be read as ABLAPL. Yes.
Item number 34.
Item 34, Your Lordship, may I permit to place this matter on behalf of Mr. Naik, Your Lordship?
Yes.
Obliged. Your Lordship, this is a
conviction matter.
Conviction matter.
And 2016 criminal appeal.
Yes, Your Lordship.
So, how many times you have been granted interim bail?
No, nothing, Your Lordship.
So, how many years you are in custody?
Since Your Lordship 2014, that is around 9.6 years.
What is the sentence imposed?
10 years, Your Lordship.
So, what is your instruction?
I have no instruction, ma'am.
No.
See, paper book is ready, let it be taken up.
Sir, EDAG ତ ପଡୁନି 2016 ର ସେ 10 ବର୍ଷରୁ 9 ବର୍ଷ ଗଲାଣି ନା
9 ବର୍ଷ 6 ମାସ.
So you get the custody certificate.
My lord, I will obtain.
बाकी शुनानी ପାଇଁ ତ ଅଲଗା କଥା ଲେଖନ୍ତୁ. The Learned Counsel for the IA number so and so, this is an application for bail. Learned Counsel for the petitioner submitted that out of 10 years of substantive sentence imposed by the Learned Trial Court, The petitioner has already undergone more than 9 years of sentence. And
9 years
counsel for
6
the
months.
huh?
9 years 6 months.
9 years 6 months. The land and counsel for the state seek some time to obtain the custody certificate. Who jail le achandi kuhuntu? Put up this matter in the week commencing from 15th April 2024. Custody certificate to be furnished. Yeah.
15th April.
15th April.
Deep place.
Item number 35.
Map link.
Item number 38.
Decision
সেটা এই যে লাস্টটাও সেটা পুরা এটা କରିଦେଲା ପରେ ସେ ପୁରା ସେ ଅର୍ଡରଟାକୁ ତଳଟାକୁ ପୁରା ଅର୍ଡରଟାକୁ କପି କରି ପେଷ୍ଟ କରିଦେବ ନେକ୍ସଟ
And this is an application for early hearing. The appellant has been convicted in the trap case. Now she is suffering from cancer and she is being treated in the Tata Memorial Hospital.
already prepare the paper book and file. We'll see. This is an application for early hearing. The learned counsel for the appellant submit that he is ready and willing to prepare the paperwork, required number of paperwork, and file the same. Put up this matter for consideration of the interim application after the paper books are filed and the same is found to be in order. Yes.
May I, can I get the copy of the charge and accused statement?
All these things are available there.
Now,
The certified copy, the original record is not coming now. It is only the scanned copy is coming. So
I have to obtain from
the certified copy, the original record is there. So
My presence में kindly note.
Acha, Mr. Sanjay Kumar Das, Learned Standing Counsel for the Business Department is present. Yes.
Item number 39.
May I please? Appellant in custody matter 2
made, my lords.
50.
My lords.
Yes.
Thereon, the name of the appellant petitioner has been reflected as Vinod Kumar instead of Kapilendra Naik, my lords.
Modification of the correction of the order date.
Paragraph 2.
Take go contra is on 50.
Yes, and the date of judgment is also to be
Corrected, my
corrected, my lords, which is in the IA 5.
Just a minute. Item number 50. What do you want to modify?
My lords, in the second page, the name of
No,
the
order dated 19/3/24.
my lords.
Page
Ah.
number 2.
Page number?
2, my lords.
Yeah.
The third subpara, the appellant petitioner has been named as Vinod Kumar, while as the appellant's name
Acha.
is
All
Kapilendra Naik.
right. Mention that this IA is for modification of the order dated 19/3/24. After hearing the Land and Council for the party, where is the standing council for the Vigilance Department? Lekhi diyon tao na lekhi diyon. In the fourth line of the order number 2 dated 19/3/2024, the name Binod Kumar shall be read as Kapilendra Naik. How kon bole ji?
My lords, on the third order in IA number 569 of 2024, the date of judgment has been wrongly typed. My lords.
Seti kete habo?
That is 21/2/2024.
Acha. And in the order number 3 dated so and so, the date of judgment shall be read as 21/2/2024 in place of 25/1/2024. How kon hai ji?
No, my lords.
Okay, the rest part of the order stands.
My lords, I prefer urgent copy.
All urgent certified copy.
Deeply obliged. My lords.
Wait, please, Your Lordship. All right. Here the present appellant, who is the petitioner in the application under 390/89, my lord, has been convicted for the offence under Section 7 of the Prevention of Corruption Act and has been sentenced to undergo RI for 3 years and to pay a fine of rupees 5,000, my lord. Here, my lord, to substantiate the allegation, the prosecution has examined around 12 witnesses, my lord. Out of the witnesses examined by the prosecution, my lord, PW4 is the complainant decoy and PW5 is the overhearing witness, my lord. If my lord will construe the evidence of these two witnesses and my lord will reach at a conclusion then there is a case, then I have no case. And if my lord will see that this evidence cannot be taken note of to convict the appellant or to reach at a conclusion that the appellant is guilty of the offence for the offence under Section 7 of the Prevention of Corruption Act, then I have got a case, my lord. Because I do not want to kill my lord's valuable time, my lord, because I was going through all the judgments delivered by my lord, and all the judgments, in fact, has been taken note of by all different judgments of my lord, my lord. At this juncture, my lord, I want to draw my lord's kind attention to the evidence of PW4. My lord, I see High Court report about PW4. PW4.
His name is Babuja Pradhan.
Babuja Pradhan, my lord.
Yes.
My lord, we see paragraph 2. On 6/11/19, I was working as the president of Regional Vishwakarma Shramika Sangha, Tikavali. The above named applicants named mean Pala Nirod Pradhan, Gajapati Pradhan, that is in paragraph 1. Nirod Pradhan, Gajapati Pradhan, Kunti Mala Pradhan, and Indira Kaur. The above named applicants had submitted their applications before the accused Ranjan Kishore Behera
although they have applied for the benefits, but their applications were not processed. On 6/11/2019, I went to Vigilance Office and told them that I want to give some money to the accused Ranjan Kumar Behera and requested them to help in passing the applications of the beneficiaries. I met with Kshatriya. Kshatriya is ballot PW11, who is TLO, and told him that I want to give rupees 15,000 to the accused. I have not submitted any written report before the vigilance. Paragraph 3, ballot. On 7/11/2019, when I again met Kshatriya sir, he asked me to produce 15,000 before him and told me to wait outside. After some time, Kshatriya sir called me and handed over the said 15,000 being wrapped in a 4-fold white paper and told me to give the same to the accused. I, along with Nilakantha sir, went to labor office. Other 4 to 5 persons also came to labor office. I parked my motorcycle under a mango tree standing in front of the labor office. Thereafter, I entered inside the labor office. Nilakantha sir and others went outside the labor office. I saw that the accused was sitting on his seat. Other staffs were working in that room. When other staffs went outside, I told to the accused to take some money and do the work of the applicants. The accused refused to accept any money from me and further told that he would do the work.
Just true.
The accused had not demanded any bribe from me,
Wait.
but I voluntarily.
This Kshatriya sir is the PLO.
My lord. PW11.
I want to take this. Yes, go on reading.
My lord. After 10 minutes, the vigilance inspector, Nilakantha Sahu, and others entered inside the office room of the accused. They took the accused with them to the vigilance unit office. I also went to the vigilance unit office with them. In the vigilance unit office, they prepared some documents and I was asked to put my signatures. Accordingly, I put my signatures in some documents. After some days, the vigilance staff brought me to the court and I gave my statement before a madam in the court as per the instruction of the vigilance inspector madam. I was not examined by the IO. In this case, the Law and Special PP showed the signature available in the FIR to the which the complainant admitted. This is my signature on the FIR marked as Exhibit P11. I had not signed in any document on 6/11/2019. Exhibit 6/2 is my signature, so and so is my signature. So he was declared hostile and leading questions are put to him. In paragraph 5, my lord, will see
Just a minute. Please, paragraph 5.
But on 6/11/2019, for the first time, I had gone to the district level office. I had never talked with the accused before 6/11/2019. I had helped the beneficiaries without giving any bribe to any
That
level.
date which is mentioned
1/11, madam.
in the FR.
1/11. I had not collected money from the beneficiaries. I had not stated to the beneficiaries regarding payment of rupees 15,000 to the accused. I had brought 15,000 to give to the accused out of my own calculation. I had submitted application for other beneficiaries. I had not gone to the accused before I went to Vigilance Unit Office. I cannot say who scribed the affair.
Just a minute. I had. Yes.
Yes, but I had submitted applications for other beneficiaries. I had not gone to the accused before I went to Vigilance Unit Office. I cannot say who scribed the affair. I had not gone to Vigilance Office before 6/11/2019. I came to know Mr. Babu and Nilakanta Babu at Vigilance Unit Office. It is a fact that I have stated before the Lord and Magistrate that the accused was demanding bribe of rupees 4,000 each from the 4 beneficiaries, altogether 16,000. I had stated before the Lord and Magistrate I was tutored by the Vigilance Madam. It is not a fact that I have stated before the Lord and Magistrate that the accused district level officer was demanding 15,000 for processing the applications of the beneficiaries, and that on being aggrieved, I submitted a written report before the Vigilance Office, and that, basing on my report, the Vigilance Inspector told me to come on 7/11/2019 along with 15,000 and 4 beneficiaries, and that I had been to Vigilance Office with 15,000 on 7/11/2019. It is a fact that I had stated before the Lord and Magistrate that I had handed over rupees 15,000 to Mr. Babu at Vigilance Unit Office. It is not a fact that I had stated before Lord and Magistrate that Mr. Babu noted down the numbers of and denominations of 15,000 in a paper. It is not a fact that I had stated before Lord and Magistrate that on seeing me, the accused asked me how much money I had brought and demanded to give the said money to him, and he told me that after receiving the money, he would do the work. It is a fact that I had stated before the Lord Magistrate that I gave the money by bringing out the same from my pocket. It is not a fact that I had not stated before Lord Magistrate that the accused received the money from me in his right hand and counted the same by using his left hand, and that accused kept the said money in the right side pant pocket, and that the said money was consisting of 7 numbers of 2000 GC note and 2 numbers of 500 GC notes. It is not a fact that I had, as stated before on Magistrate, that on being asked by the vigilance staff, I told that I had given rupees 15,000 to accused, and that then the accused brought out those money from his pant pocket and tried to swallow, and that when the vigilance inspector tried to bring out those money from the mouth of the accused bite his left thumb, and that the hand washes of the accused were taken, which turned into pink color, and that when the mouthwash of the accused was taken, that was also turned to pink color, and that when the pad pocket wash of the accused was taken with sodium carbonate solution, the same was also turned into pink color, and that I was present there, and that the vigilance inspector seized those money and the solutions. It is not a fact that I am suppressing the truth. It is not a fact that I submitted the affair. It is not a fact that I collected money from 4 beneficiaries to give bribe to the accused. I know PW3 It is not a fact that I had collected rupees 1500 from Gajapati Pradhan. It is not a fact that being gained over by the accused, I am deposing falsehood to save him from legal liabilities. Nothing was seized in my presence. It is not a fact that on the basis of my affair, this case has been initiated. Cross-examination, my lord. The Vigilance DSP and the lady inspector went to the district level office on 7/11/2019, and they entered in the room of the accused. I was not examined by the IO in connection with this case. I went to the land magistrate with the Vigilance madam as per the instruction of the Vigilance Inspector K.K. Pradhan. Madam, I had given my statement before the land magistrate. I had not given my statement voluntarily before the land magistrate. When I gave my statement, the vigilance inspector was also there. I had never gone to accused before 7/11/2019 with regards to the applications of 4 beneficiaries. The distance between the district level office building and the entrance boundary gate is about 15 feet. After 10 feet from the building, there is an entrance door, and from there, after going 10 to 15 feet towards right, the chamber of the accused comes. There are 2 door lifts to enter the chamber of the accused. That is, the first one is wooden door and the second one is glass door. When I enter inside the chamber of the accused, the glass door automatically closed. The size of the room would be 12 inch into 12 feet into 14. The seat of the accused was not visible from outside. I had not seen Nilakantha Sahu standing outside the chamber of the accused. I thrusted the money in the right side pant pocket of the accused by keeping the same in a white envelope. The affair was not described as per my version. I put my signature on the affair on 7/11/2019. I put all my signatures on the documents after I returned from the DLO office. The contents of those documents was not read over and explained to me. I had also not gone through the contents of those documents. On re-examination, on being called by prosecution, in paragraph 13, the rehabilitation assistant applications forms of Kuntimala Pradhan, Indira Kahara, Nirod Pradhan, and Gajapati Pradhan of Tikavali block have been filled up by me in my own handwriting. I put my signature on a FIR in English language. I read up class 5 on 6/11/2019. I had gone to the vigilance office, Fulbani, voluntarily to lodge a FIR. It is not a fact that I have not stated before the police that after some time, Kshatriya Sar called me and handed over the said 15,000 being wrapped in a 4-fold white paper and told me to give the same to the accused. It is not a fact that I actively participated in the preparatory meeting, including the demonstration of chemical reaction, and that I narrated the affair allegation before the other witnesses of the trap team. It is not a fact that I have not stated before the police during investigation that the accused had not demanded rupees 15,000 from me. I thrust rupees 15,000 in the pocket of the accused. It is not a fact that Vigilance Inspector K.K. Pradhan was not present while my statement was recorded by learned magistrate, and I had given my statement voluntarily before the learned magistrate. It is not a fact that I am suppressing the truth to help the accused. Cross-examination. I had not seen the accused prior to the date of my date of trap. The accused had not demanded bribe from me on the date of trap or prior date of trap. I thrusted the 10 money inside the right side back pocket of the pant of the accused. I had not written the affair. I had not read the contents of the affair, and the contents of the affair was not read over and explained to me. I cannot say the name of the person who wrote the affair. I put my signature on the affair as per the instructions of the vigilance officials. But considering this, the evidence of PW4 in the light of the latest judgment of Neeraj Datta, which pilot has referred in earlier cases, ballot, their ballot, Honorable Apex Court has categorized ballot out of entire judgments ballot. They have categorized ballot in paragraph 70. If there is an offer to pay by the bribe giver without there being any demand from the public servant, and the latter simply accepts the offer and receives the illegal gratification, it is a case of acceptance under section 7.
Judgment reference to the
ballot that is 2023 volume 89 Supreme Court 510.
वही नहीं की चाहे कोर्ट रे
I thought ballot
no ଆପଣ ରଖନ୍ତୁ ଏଠି ରହୁନି କି ଏସିସି ଆଉ ତ ବାହାର କରିବ ତ ଓସିଆର ବାହାର କର ଓସିଆର ରେଫରେନ୍ସ କେତେ ଅଛି କି ଦେଇଛନ୍ତି ଏଇଟାରେ ବାହାର କଲ ଏଇ ଯୋଉ ଏସିସି ଟା ବାହାର କଲଠୁ ଏଠିକି ଆସ ଏପଟକୁ ଆସ What is the reference of Neeraj Datta?
That is ballot reported in OCR 2023 volume 89 OCR page
2023
volume 89
reference ଅଛି
that is OLR reference. Pilot has taken note of
no SCC
online ballot 280. In one judgment pilot has referred SCC and one judgment pilot has referred OLR.
दियालम कर दिले हां से 880 कर दे spell
SCC online page 280. Neeraj Datta versus State NCT Delhi reported in 2023 SCC online 280.
Select the last court Supreme Court find page party name spelling कहले Neeraj Datta spelling
NEERAJ DUTTA
NEERAJ
NEERAJ
हाँ तबरे
versus State Government of NCT.
पुराना डा कौन
Neeraj Datta
spelling कौन हाँ शिवराज
DUTTA
Neeraj Datta click it
constitution page.
Find case. $2000 केबे कर सेटा
2023 volume 89 OCR report decided on 15th December 2022. 15th December 2022. Honorable Justice Abdul Najib, Justice Gavai, Justice Bopanna, Ram Subramanian and Nagar.
Decided on 15 December.
510.
So 2023, Volume 4 SCC 731. Neeraj DUTTA.
That has also been reported in 2023, Volume 1 WLR.
ठीक है जी को पैराग्राफ जानता हूँ
Ballot paragraph 70.
पैराग्राफ मैच करिवनी तो
Ballot में CA.
रुन तो ऑपरेटिव पार्ट ऑफ देख लो
The categorized ballot
30 कितने को 90 no
not exactly 70. I'm just
on strategy by it
ballot में C paragraph 60.
start किम थी जी What emerges from the aforesaid discussion is
What
summarized
emerges
as
from
under.
the aforesaid discussion is summarized as under
Acha,
16.
that is paragraph 18. First she
But let me see for paragraph 67. This is also applicable to our case. Paragraph 67. The court custard.
SCC ro
नहीं OCR रो
ନାଇଁ ମ୍ୟାଚ୍ ତାଙ୍କର ଅଲଗା
ମ୍ୟାଚ୍
ଅଲଗା
କରେନି
ଶୁଣ,
ବେଲେ
just a
paragraph
minute.
68 रो ପୂର୍ବଟା
Just a minute. What emerges from the aforesaid discussion is summarized. Proof of demand and acceptance of illegal gratification by a
this
public.
paragraph starts with this court custard that
Take care on to. As in fact in issue, the prosecution is signed for now. In order to bring home the guilt of the accused, the prosecution has to first prove the demand of illegal gratification and subsequent acceptance as a matter of fact. Okay, this fact in issue can be proved either by direct evidence, which can be in the nature of oral evidence or documented. Further, the fact in issue, namely proof of demand and acceptance of illegal gratification, can also be proved by circumstantial evidence in the absence of direct oral or documentation. In order to prove the fact in issue, namely the demand acceptance, the following absurd. If there is an offer to pay by the bribe giver without there being any demand from the public servant, and the latter simply accepts the offer and receives the illegal gratification, it's a case of acceptance. Okay. In such a case, there need not be any prior demand by the public servant. On the other hand, if the public servant makes a demand, and by the way, what is the date of this EU case date of occurrence ke pehla?
7/11 minute.
No, date of occurrence.
7/11/19.
7/11/19
minute.
Date of occurrence of
Yes.
this case.
Yes.
Okay.
The case in hand ballot.
Yes. तापर ଆସିଲା. On the other hand, if the public servant makes a demand and the bribe giver accepts the demand, in both the cases, the offer and the bribe and the demand sound to respectively have to be proved. Okay. In other words, mere acceptance of receipt of illegal gratification without anything more would not make it offense under and so on. In order to bring home this, there must be bribe giver for his acceptance on prior demand. Okay, so the most important sentence, apart from other things, that if there is an offer to pay by the bribe giver, that is 88.4 D Roman 1. ମାନେ ଆପଣଙ୍କର ଯୋଉଠି conclusion ହେଇଛି ଯୋଉଠି after discussion it is summarized as under.
If there is an offer to pay the bribe,
okay,
giver without there being any demand from the public servant.
এই কেসটাକୁ ଆମେ ପକେଇବା that let us say he offered it. There is an offer to pay the bribe giver without there being any demand. As per the evidence of, let us say, there is no demand, but he offered from the and the latter simply accepts the offer
and receives the legal gratification.
So here it is also not a case of acceptance, it is a case of thrusting. Thrusting would not be acceptance. Okay, receive the, it's a case of acceptance. All right.
What I was saying, Mellard, just one paragraph before.
Yeah.
Mellard, if we will construe, Mellard, submitting Mellard fairly, Mellard, PW4 has been declared hostile by the prosecution. Mellard may see paragraph, just one paragraph before.
Now what it starts like?
This court cautioned. Therefore, this court cautioned that.
We start with this court's caution.
Therefore, this court cautioned that.
Paragraph.
Just purva paragraph.
Purva paragraph. Okay, 87. All right. Paragraph 87 and 88. Okay. The comment is 88.4 D Roman 1. Acha. 87 Colonel how the
Therefore, this court cautioned that even if a witness is treated as hostile and is cross-examined, his evidence cannot be written off altogether, but must be considered with due care and circumspection. And that part of the testimony which is creditworthy must be considered and acted upon. It is for the judge as a matter of prudence to consider the extent of evidence which is creditworthy for the purpose of proof of the case. In other words, the fact that a witness has been declared hostile does not result in an automatic rejection of his evidence. Even the evidence of a hostile witness, if it founds corroboration from the facts of the case, may be taken into account while judging the guilt of the accused. Though there is no legal bar to raise a conviction upon a hostile witness testimony if corroborated by other reliable evidence. Here, my lord is to see the evidence of PW4 vis-a-vis evidence of PW5, 10, 11, and 12. Whether that comes
we'll go one by one. Now you have placed the evidence of decoy. Right. Decoy has not stated about any demand. Decoy has not stated about any acceptance. Decoy has not stated about any recovery of money. So, has he stated about the recovery part? See the evidence once again. Whether he has, because acceptance he has not stated. He stated about thrusting of the same. About the recovery also, whether he has stated. In the other paragraphs, it is just simply this previous statement has been confronted to him, which is recorded under section 164 CRPC, and that is in paragraph number 7. It is confronted. Paragraph number 6 also confronted. All right. So
which he has stated that Madam had accompanied me throughout, and as per her instruction, I have given my statement before the
the evidence of your submission from the evidence of PW4, neither demand nor acceptance or recovery of printed money is borne out. Okay. But this 87 says that, let us say he has turned hostile, cross-examined, and so no, that
again, after cross-examination, prosecution wanted to fill up, patch up the lacuna.
No, that is what no, we are not there.
On record.
Demanded counter in terms of you come to point 88.6. That is if in the event the complainant turned hostile, your conclusion part would have.
Valid. Or has died, or is unavailable.
Or has died, or is unavailable. Hostile. Demand of illegal gratification can be proved by letting in evidence of any other witness
who can again
let in evidence either orally or by documentary evidence, or the prosecution can prove the case by circumstantial evidence. Trial
does not
does
abate,
not abate. Abate কথা তো ছাড় দিও তো। Does not, does it, or nor does it
an order of
result
acquittal.
an order of acquittal. That means, let us say that decoy has turned hostile.
My lord,
But if there are other witnesses
my lord,
who have stated about those three main aspects, like demand,
my lord,
acceptance, and
my lord,
recovery,
my lord,
and that evidence
my
is
lord,
found to be trustworthy, acceptable,
my lord.
then even though the decoy has not
Non-hostile.
supported the prosecution case,
My lord,
it would not be a ground to acquit the
my
accused,
lord.
right?
Exactly.
So let us come to the next evidence would be the
Overhearing witness, my lord.
Okay.
Yes, PW 5.
Okay, we go to that.
PW 5 is S.K.SAHOO, my lord.
Pardon.
Ballot. From paragraph 1, ballot. On 6/11/2019, I was working as junior clerk in the office of RW Division, Fulwani. On that day, as per the requisition of the Vigilance Office, I reported before the Inspector Kshatriya at Vigilance Unit Office, Fulwani, at about 6 p.m. Inspector Kshatriya sir instructed me to come on 7/11/2019 at about 11:30 a.m. Accordingly, on 7/11/2019, at about 11:30 a.m., I reached at Vigilance Unit Office, Fulwani, and I met with Inspector Kshatriya sir. On my arrival, I found two vigilance staffs, one official witness, Srikanta Mahanti, and complainant were present there. Inspector Kshatriya sir introduced us with the complainant. The complainant was the president of Labor Union, Tikabali. The complainant had talked with district labor office regarding the death compensation of 4 laborers. The district labor officer had demanded bribe of rupees 16,000 from the complainant to process the documents. The complainant expressed his inability to pay rupees 16,000, but subsequently it was settled at 15,000, for which the complainant reported the matter before the vigilance office. The complainant narrated the above facts before us. Thereafter, the complainant produced rupees 15,000 in shape of 7 numbers of 2,000 GC notes and 2 numbers of 500 GC notes before us. Mohanty Babu noted down the numbers and denominations of these notes in a plain white paper. Then I signed on the said plain paper. Mohanty Babu was instructed to compare the numbers and denominations of the recovered money with the numbers he noted down in the said plain paper. Thereafter, one vigilance staff showed the chemical reaction. The said vigilance staff brought some solution in a plastic disposable glass and dipped his fingertips inside it, which did not change its color. Then he smeared the chemical powder.
You skip those that.
My lord, on my lord, we come to the 8th line.
Okay.
That's because the said solution, my lord, I was instructed to accompany Babuja Pradhan. Babuja Pradhan is my lord PW4.
Right.
To the spot to see the transactions and to relay the signal by rubbing my head with my hand. Take note of this, ballot. Thereafter, a report was prepared there. Next, ballot, we see paragraph 3. We reached near a mango tree available at the district labor office. The inspector sir again briefed us about our respective duties. Then I myself and the complainant went to the district labor office. The office staffs were present at a visible distance from me. The complainant entered inside the chamber of the accused. I remained outside the door of the room. The complainant talked with the accused. The complainant also took the papers of 4 persons. The accused asked the complainant whether he had brought the bribe money or not. Thereafter, the complainant gave the bribe money to the accused. Thereafter, the complainant came out from the chamber of the accused and informed me that he had given the bribe money to the accused. This is in his chief, my lord.
Okay, so
If my lord will,
this witness has stated
that I had seen it.
No, he had seen, but stated about the demands also acceptance.
My lord.
Accused asked the complainant whether he had brought the bribe money or not. So this is a demand thing.
But
then,
my lord,
we'll
remember
go,
at this stage, he was outside. Room was closed.
No,
and
no,
it was.
It is, Mr. Dhal, it is not a stage. I am not hearing the criminal appeal on.
My lord.
So let us see that. Let us understand it.
My lord.
The complainant had also took this one. So the accused asked the complainant whether he had brought the bribe money or not. Thereafter, the complainant gave the bribe money to the accused. The complainant came out from the chamber of the accused one. So this witness, PW5's evidence in chief, it goes to show about the demand and acceptance. Okay, then what he has given the signal, then the inspector. Yes, next, you please continue what happened after the, where from it was recovered. You come to paragraph 4. Okay. The accused put, this is, the accused put the bribe money. The inspector asked the accused to reserve, which he denied.
Bribery to which he denied.
The accused put the bribe money into his mouth. When the inspector tried to bring that said money from the mouth of the accused, the accused bite the fingers of the swan-so. Okay. Manti Babu compared swan-so. The right hand was of the accused was taken with sodium carbonate solution, which turned pink color. The left hand was of the accused was also taken in sodium carbonate, which also turned pink color. The mouthwash of the accused was taken in cotton swab. Cotton swab was dipped in swan-so, which was also pink color. The C report also indicates that this hand wash, both the hand wash, also the mouthwash, which was sent for C examination, that contains that powder. So now you tell me that, let us say that that witness has not supported the prosecution case. And
this witness, PW
yes
5, whether he was in a position to see it or not.
No, that is to be.
We are saying so.
That is to be accepted at the stage of whether I am not going to appreciate the evidence.
Well, if that will not be appreciated, then my lord, he has stated so in chief.
No. What have you elicited in the cross examination?
My lord, that I want. My lord, yes, paragraph 10.
Paragraph number 10. Yeah.
Let me see paragraph 9. I had put my signature on the plain paper affair, in which the numbers of denominations of GC notes were noted down. I also put my signature on the said plain paper. When the said paper was seized, it is a fact only one signature of mine is available in the plain paper. It is false to say that I put two signatures on the plain paper. The DSP and Inspector Vigilance had told me about this case. The DSP Vigilance, Inspector Vigilance, and other two staffs of the Vigilance, myself, the complainant, and another official witness went to the spot. I do not remember the number of bike in which we went to the district level office. The other trap team members remained at an approximate distance of 15 to 20 meters before main gate. I cannot say the positions of other trap team members when I went inside the DLO office. I do not remember after how much time I saw Inspector Kshatriya after I went inside the DLO office building. There was a wooden door and a glass door affixed to the entrance of the chamber of the accused. The wooden door was on the front and the glass door was at the back of the wooden door. And he was outside the door of his ballad. Wooden door and glass door was intervening in between, my lord. I put some signatures at the spot and some signatures at vigilance unit office. I do not remember how many signatures I put at Vigilance Unit Office, and also I do not remember how many signatures I put at the DLO office. I cannot say the total number of signatures which I put on 7/11/2019. I do not remember when I again met with any vigilance. And after 7/11/2019, I had given my statement before the magistrate. Except the magistrate, I had not given any statement before any other officials. The tainted money was inside the pant pocket of the accused before he tried to swallow the tainted money. I do not remember in which side of the pant pocket the tainted money was kept. It is a fact, this is important, my lord, it is a fact that I have stated before the London magistrate that the complainant went inside the chamber of the DLO and I remained near the door of this chamber, and that the complainant gave me signal. Thereafter, I relayed the signal to the other trap team members. Before the complainant gave me signal, I had no knowledge regarding the transaction. So how could he see? Well, he says, I have seen, they discussed, I have heard it, I had seen the transaction, and he had no knowledge about the transaction.
Wait. Read paragraph 13.
I do not remember whether I had not stated before the Lord Magistrate that we reached near the mango tree available at the district labor office, and that the other staffs were present at a visible distance from me, and that the complainant had also took the papers of 4 persons, and that the accused asked the complainant whether
It
he
is
had...
not there in this. These lines are not there in 164.
My lord.
We pass on that 164. 164 of this Nilakantha Sahu.
Must have seen. It 161 na? Magistrate by. जड़ा पड़ने
Dear.
এইটা নাই এই পচরাইছে নাই
164 CRPC statement mark each exhibit.
itu kan dostat
Exhibit P16.
P16.
P for Puri 16.
P16. Nice.
May I pray before your lordship to take it on Saturday?
Yes, just. এটা হচ্ছে P17 টা হଉଛି ନା
P16.
ହଁ ନାଇଁ P12 ଟା ହଉଛି ୟାର ଷ୍ଟେଟମେଣ୍ଟ ଯୋଉ ଡିକୟର ବାବୁଜା ପ୍ରଧାନ
ଡେକର ହଉଛି P12.
ହଁ ରାଇଟ୍
B16 ଟା ହଉଛି PW5 ର।
ଟିକେ ରହ P16 ଷ୍ଟେଟମେଣ୍ଟ ଏପଟ ସେପଟ ହେଇକି ଅଛି ସେ ମଧ୍ୟ କମ୍ପାନୀ ପରିଚୟ କରେଇଲେ ଆଚ୍ଛା ଏଟା ଏମିତି କିଏ ପ୍ରିଣ୍ଟ ଆଉଟ୍ କରିଛି ଗୋଟେ ଏପଟୁଆ ଗୋଟେ ଏପଟୁଆ କଣଟା ଆମମାନେ ଆଗ ପଛ ହେଇଗଲୁ ତାପରେ ଆମେ ବାହାରେ ରହିଲୁ ପୂର୍ବରୁ କଥା ହୋଇଥିବା ଅନୁସାରେ ହାତ ଠାରିଲେ ଜାଗା ଘରକୁ ଆଚ୍ଛା ଯିବା ପାଇଁ କଥା ହେଲୁ ଡିଏଲଓ ଅଫିସ ଭିତରକୁ କମ୍ପ୍ଲେନାଣ୍ଟ ଯାଇ ଡିଏଲଓଙ୍କ ଚାମ୍ବରକୁ ଗଲା ମୁଁ ଡିଏଲଓଙ୍କ ବାହାର କବାଟ ପାଖରେ ଠିଆ ହୋଇଥିଲି କାମ ହେବା ପରେ କମ୍ପ୍ଲେନାଣ୍ଟ ମୋତେ ହାତ ଠାରିଲା ମୁଁ ଅନ୍ୟମାନଙ୍କୁ ହାତ ଠାରି ଡାକିଲି ତାପରେ ଆମେ ସମସ୍ତେ ଯାଇ ତାକୁ ଚାମ୍ବର ଭିତରେ ଧରିଲୁ so it is correct he has not stated about this demand and acceptance in the 164 CRPC statement
ଫାଷ୍ଟ ପେଜ ରେ ଅଛି
correct କୋଉଟା
ଫାଷ୍ଟ ପେଜ ତାରି 164 ର ଲାଷ୍ଟ ବଟମ 4ଟା ଲାଇନ
କୋଉଟା
ସେଇ 164 ର ବଟମ 5ଟା ଲାଇନ
କଣଟା ପଢୁନାହାନ୍ତି କଣଟା
ସେ ମତେ କମ୍ପ୍ଲେନେଣ୍ଟ ନାମ ବାବୁଜ ପ୍ରଧାନ ବୋଲି କହିଲେ ଯେ କି ଟିକାବାଲି ଲେବର ୟୁନିୟନର ପ୍ରେସିଡେଣ୍ଟ ରୂପେ କାମ କରନ୍ତି ତାପରେ
କୋଉଟା ପଢୁଛନ୍ତି
ଫାଷ୍ଟ ପେଜ ତାରି ସେଇ P16 ର ଫାଷ୍ଟ ପେଜ ଟୁୱାର୍ଡସ ବଟମ ସେ ମତେ କମ୍ପ୍ଲେନେଣ୍ଟ ନାମ ବାବୁଜ ପ୍ରଧାନ ବୋଲି କହିଲେ ୟୋର ଲର୍ଡସିପ ଗଟ୍ ଇଟ ଯିଏ କି ଟିକାବାଲି ବ୍ଲକ ର
ସ୍ପଟ କଥା ପଡିଛି ସ୍ପଟ ରେ ଯୋଉ ଭିତରେ ପଶିଲା ପରେ ଯୋଉ ଡିମାଣ୍ଡ ହେଲେ ଏବଂ ଆକ୍ସେପ୍ଟାନ୍ସ ଯୋଉଟା କି ଚିଫ ଏକ୍ସାମିନେସନ ରେ କହୁଛି that is not there in the 164 set
ନାଇଁ ଡିମାଣ୍ଡ 15,000 ଟଙ୍କା କରୁଛନ୍ତି ବୋଲି ସେ ସେଟା କହିଲେ
total demand ହି ନାହିଁ acceptance ନାହିଁ in the 164 in the inside the office of that accused that is not there in the 164 that has been confronted here in paragraph number 13 So, if these two things are taken away now, he has turned hostile, overhearing witness, if his evidence is also acceptable, corroborated by the other evidence, then also the decision says that conviction can be sustained.
Valid.
But it is to be seen that whether from the other evidence all these three aspects are established or not. That means demand, acceptance, and recovery.
Valid.
So if PW 5 has stated about all these three things in the chief examination, and two things are taken out of it
Valid.
because it is not stated in 164.
Valid.
The only thing remains is the recovery.
Recovery of money, and that has been decided by my lord and honorable apex court. We are receiving.
Yes, Mr. Das, what is your submission?
Your lordship may kindly refer to judgment page 69.
Yes. Judgment page 69. Yes.
Running page.
Running.
Yes.
Further, from evidence of prosecution witness PW2, PW4, PW5, PW8, PW9, PW10, PW11, and PW12, and other witnesses, it is forthcoming that the accused, being a public servant, demanded rupees 15,000 from the complainant.
How they have stated?
They have stated. Your lordship may kindly have a glance.
No, they have stated because at the preparation stage they might have heard it from the
complainant directly,
right?
There, yes.
So they are not the direct witness to the demand or acceptance. Whatever their knowledge is, that their knowledge is from the source of the complainant.
Yes,
right?
exactly.
Okay.
So
only now, you see, prior to the date of occurrence, the demand aspect is obviously usually stated by the decoy, right? Because thereafter he lodges the first information report.
Yes,
right? So in this case, that part is not there because he stated, I have never met. Now, if you come to the as on the date of trap re, obviously in this sort of case, demand ଆଉ acceptance ର evidence ଥାଏ ଦି ଜଣଙ୍କର witness ପ୍ରାୟ
overhearing and complaint.
overhearing and decoy. ଏଠି decoy hostile ହେଇଗଲା. overhearing witness chief examination ରେ ଆପଣ case କୁ support କଲା. କିନ୍ତୁ cross ରେ ଯେତେବେଳେ ତାକୁ ପଚରାଗଲା ଯେ ତମେ 164 ରେ demand ଆଉ acceptance ଭିତରେ କିଛି କହିନ, he stated not, it's not, and now it has been exhibited and it shows that in fact he has not.
He said, I do not remember.
Sorted. Now we have verified the document, it's not there. So যদি not there তাহলে a statement first time আসছে court রে जो demand or acceptance by the overhearing
witness.
So if it is coming for the first time and it is excluded.
Now, in the chief, your lordship has already heard that the complainant narrated before them when they were present at the time of prior to preparatory, from whom they heard.
Again, let us say he has heard.
They have heard.
That is not the direct evidence, that their knowledge is based on the source that is given by Mr. X. Mr. X is the main person.
Yes.
If Mr. X has disclosed it before A, B, C, D.
Yes, ma'am.
If Mr. X turns hostile.
Yes.
Then the evidence which that has been given by the other witness, that becomes hearsay evidence.
Yes.
That is not admissible under section.
Yes, maybe hearsay evidence, but all other circumstances is taken together.
Maybe hearsay. Let us go in a way the evidence is to be appreciated. If their evidence cannot be accepted because the main witness has not supported.
Yes.
Main witness hearsay evidence कौन ना ମୁଁ କହିବି ମୁଁ ଏମାନଙ୍କୁ କହିଲି ମୁଁ support କରୁଥିବି ଏମାନେ କହୁଥିବେ ଆମେ ଏଇ source ରୁ ପାଇଲୁ ତାହେଲେ ସେ evidence ଟା acceptable ହବ. ମୁଁ ଯଦି ନିଜେ ହିଁ କହୁନି ଏବଂ ମୁଁ କହୁନି ଯେ ମୁଁ ଏମାନଙ୍କୁ କହିଥିଲି ତାହେଲେ ସେମାନେ ଯଦି କହିଲେ ଯେ ଆମେ ଆଠୁ ଶୁଣିଲୁ ସେଟା ହେଇଗଲା ଶୁଣା କଥା. ଶୁଣା କଥାର evidence ର value କିଛି ନାହିଁ in view of section 60 of the Evidence Act.
Your lordship is absolutely correct. But so far Neeraj Datta case is concerned, even if he is declared hostile.
ସେଇଆକୁ ଆସୁଛି ଆପଣଙ୍କୁ hostile ହେଲେ ଆପଣ ଛାଡି ଦିଅନ୍ତୁ ଆ evidence ଟା. ମୁଁ ସେଇଥିପାଇଁ ତାଙ୍କୁ ପଚାରିଲି chief examination ପର୍ଯ୍ୟନ୍ତ we are satisfied that this witness has built up some
PW5 overhearing.
किंतु जेतेबेले आपनकर 164 कन्फ्रंट हे गला 164 रो सेई जो दीटा तीनटा लाइन मिली गला जे से डिमांड कथा कहिनी एक्सेप्टेंस कथा कहिनी खाली कहिची सिग्नल देला ये जणेला तेणु obviously this witness overhearing witness is not a witness to the demand, this overhearing witness is not a witness to the acceptance. Now आउ ताले से एविडेंस रहिला कोन ना से एविडेंस रहिला रिकवरी पार्ट से रिकवरी पार्ट is corroborated by the other witnesses हला
Your Lordship is absolutely
right
correct.
including that the circumstances are that the hand wash have turned pink, right? And also the saliva part has turned
Yes.
pink. Question is that let us say that the evidence to that effect, recovery part has been proved beyond all reasonable doubt. Hala? Recovery part, conduct of the petitioner.
Acceptance part.
Acceptance could
Acceptance न होले हाथ दिटा नाली को उठाइला ए पिंक कलर if he has not received
acceptance जणे कहिबाकू पड़िबो ये ताकू काउंट कला I am
हाँ it is there I will satisfy your Lordship.
Thrusting of the money whether you mean to say that thrusting of the money is equivalent to acceptance.
I will satisfy your
no.
Lordship that he himself has received the money. He has counted by both his hands and thereafter he put it in his own pocket. I will satisfy from the evidence.
We will go to that. You see, what you have proved when the best person has...
My Lord, Deco, it is true that Deco has been gained over. Number my first point. Deco has been gained over. Deco has not supported the prosecution case.
Not supported the prosecution.
Yes, he has been gained over and declared hostile by the prosecution.
You cannot use the word gained over, particularly when your witness is saying that I have gone to give the statement with the vigilance inspector.
No, he has changed the version from time to time.
So how can you say it?
No, my Lord.
It has happened like that.
He himself has, my Lord, proved the FIR.
Whatever.
I am my submission before your Lordship that whatever now it is an application for consideration of 389 for stay of conviction or not. Mainly, I rely upon the decisions of your Lordship. Besides, another judgment of our now present Honorable Chief Justice when his Lordship was at Patna High Court. So, it is not the position to go through the evidence of the witnesses at the time of consideration of 389 application.
First overcome Orissa, then we'll go to Patna.
No. I am citing the decisions which your Lordship has observed that at the time of this consideration of 389, evidence that it cannot be said that there is no evidence against the present appellant or petitioner. I am relying on your Lordship's observation. So it is the application of 389.
Try to have, develop an habit of listening. Then you can understand and reply it properly. I'm posing you a question that when the decoy has not supported the prosecution case, when the overhearing witness, though stated in the chief examination about the demand and acceptance, has stated that he has, in the cross-examination, it is brought out that he has not stated about the demand and acceptance. So the only thing remains in the case of the prosecution is recovery. Whether you are trying to advance an argument that in a case where the recovery part is proved beyond all reasonable doubt, that would be sufficient to establish a charge under this offense?
I will go through this. I will go through the recovery only if recovery, as your Lordship, whether only recovery can be.
You see this decision itself, please come to this Neeraj Datta. Please come.
That decision with me.
Just a minute. See that.
I have relied on that decision in my objection.
This decision was also subsequently
decided acquitting the appellant.
No. This decision, 5-judge bench decision, was dealt with subsequently by another bench. I think it is 2-judge bench or 3.
Yes, my Lord, 2-judge bench.
They stated that this was taken into account while considering the new act but the old act was not taken into account.
Yes.
That was the
Yes, yes. That was the
and
question.
they clarified that whatever it may be, the prosecution has to establish all these three things. Without the three things, that means demand, acceptance. They have stated about considering the old act. Here is this case which is governed by the old act or new act?
New act.
New act, right?
7.
No, no, ये present case टा.
In the present case, 7 new act.
New act रे आइछि. तेणु new act रे जदि हबो तेलु आमे old act रो से जो decision को जीवा दरकार नहीं. तेणु new act रो decision अनुଯାयी 5 judge bench decision is very clear and 88 रो जो प्रथम जोटा लेखा आइछि, what emerges from the aforesaid discussion is summarized that proof of demand and acceptance of illegal gratification by a public servant as a fact in issue by the prosecution is a sine qua non in order to establish the guilt of the accused. So how do you say from which evidence, if this two evidence is taken away, the evidence adduced by the decoy, the evidence adduced by the overhearing witness or the shadow witness, so far as demand and acceptance is taken away for these reasons, but it has been stated. How do you, from which evidence you are to prove these two aspects, demand and acceptance?
I will satisfy. Picked, I will go through that Nirav Datta's case, excluding this area. Next week, as your lordship deems fit and proper. Next week, Friday.
Next week.
No, next week. आपण 6th रे कोन कहउथिले परा?
शनिवार था.
शनिवार is a working day, huh?
Yes.
Okay, so keep it on 6th.
May I pray? I have filed the citations, so your lordship may kindly have a glance. To I have relied on, and only one first page may kindly be seen. First page.
So many cases have been dealt with in these all these cases. So many citations have been reflected. So
No, I in my objection, I have relied on so many decisions, including your lordship's decisions, 4 number of decisions, and the first page, which is a new one.
IN number ta likhibe, hala? Hard Mr. DP Dhar, land senior advocate, and Mr. Sanjay Kumar Das, land standing counsel for the Vigilance Department. Put of this matter on 6th of April 2024. hala? अच्छा लिखी देवे the land and standing counsel for the Vigilance Department files कौन file करे?
First page, your lordship's observations, and this only one decision which your lordship might not have gone through. First page,
some citations, some sites. Alright.
Our present.
What is it? शनिवार दिन press करिए.
हाँ, ये हमारा justice जे वर्तमान honorable अछंती
citations हला citations which are taken on record. आपण किसी अजी file कर लेंगे?
नहीं, कौन?
You make a short note.
ମୁଁ ଏଥର ଦେଇ ଦେଇଛି
Right, so
ଆଉ ବଞ୍ଚ ଦଉନି
okay
on 6th madam.